The Law Factor with advocate Clarence Arenas-Gandawa.
Greetings of the day. Surveillance used to mean a man in a trench coat. Now it means a camera on every corner, a microphone in every phone, a tracker in every app. Governments say it is for safety, corporations say it is for service. But citizens must ask, safety for whom, service for whom, and at what cost? Because when the state sees everything, the citizen sees nothing. And when the citizen sees nothing, power becomes invisible and therefore unaccountable. Privacy is not a luxury. Privacy is liberty's last line of defense. The new panopticon, watching without being seen. Modern surveillance is silent. It does not knock. It does not announce itself. It simply observes. CCTV networks map your movements. Cell towers track your location. Apps harvest your habits. Biometrics store your identity. Social media predicts your behavior. This is not science fiction. It is the daily architecture of modern life. And the danger is not the technology. It is the absence of rules governing its use. When surveillance expands without oversight, the state becomes a watcher without a warrant. Let's look at a case study. A taxi driver in Nairobi was stopped at a checkpoint. Police claimed his phone placed him near a protest. He had never attended, he had never marched, he had simply driven past the area on a job. But the system flagged him, and the flag became suspicion, and suspicion became detention. He was not arrested by evidence, he was arrested by data. This is the danger of surveillance without safeguards. Innocence becomes an algorithmic accident. Judicial responsibility, courts as guardians of privacy. Judges must treat privacy as a constitutional pillar, not a convenience, not a courtesy, a right. Courts must demand warrants for digital searches, limits on data retention, proof of necessity and proportionality, transparency in surveillance operations. Because unchecked surveillance is not security. It is state overreach wearing the uniform of protection. The robe must defend the citizen from the eye of the state. Let's talk Parliament, legislating the boundaries of power. Parliament must draw the line, not with slogans, with statutes. Laws must require independent oversight bodies, public reporting on surveillance use, strict rules for biometric databases, criminal penalties for unlawful monitoring, citizen rights to access and correct their data. When Parliament is silent, surveillance becomes improvisation, and improvisation is the birthplace of abuse. Public education. Privacy is civic power. Citizens must understand what data they give away, how their devices track them, how to challenge unlawful monitoring, how to demand transparency. Privacy is not paranoia. Privacy is protection, and protection begins with knowledge. Radios, schools, churches, chiefs' councils, these must become classrooms of digital rights. Eswatini in focus, the unregulated eye. In Eswatini, surveillance is expanding quietly, cameras multiply, telecom data is accessible, digital monitoring lacks oversight. There is no independent data protection authority, no statutory limits, no public reporting. This is not sustainable, this is not safe, this is not constitutional. Eswatini must legislate before surveillance becomes normalized. Because once privacy is lost, it is rarely recovered. A state that watches without restraint is a state that governs without consent. Surveillance without oversight is power without accountability. The law must protect the citizens' rights to live unobserved, unchecked, and unmonitored, unless the Constitution demands otherwise. Do not fear technology, fear its misuse. Do not reject surveillance, regulate it. The law moves forward, you must move with it. See you next Thursday. The work continues.
Springfield Law Clinic, justice defined, rights protected. We are here to serve.